Welcome back. A federal lawsuit is being filed against FedEx over allegations the company violated discrimination laws. The lawsuit claims the company is discriminating against blind employees at a North Carolina facility in Kernersville. That includes the denial of accommodations that would allow for employees to complete their jobs.
Joining us this morning, our chief legal analyst, Khalif Rhodes. Khalif, good morning. When you look at this lawsuit, what kind of jumps out?
This is a very, very disturbing, let me say that, but also normal within the course of business for an EEOC claim. You allege as the employee that there's something going on and you need to go through and exhaust the administrative remedies. Attempt to tell the folks that's directly in charge, some supervisor, hey, there's a violation. Specifically, you guys are not making accommodations for employees that have blindness as an issue. So what they do is they take it to those guys and their responses are not what they believe are appropriate. And so then you take it to the EEOC. Now, this is where it, again, follows the normal path. The EEOC will do their own investigation. I've participated in a number of these claims. After the EEOC does their investigation, they can do a number of things. They can say, hey, we have reasonable cause to believe that no violation occurred, and then that will be the end of it. Or they can say, we believe there's reasonable cause to believe that there was a violation that occurred, specifically failing to create and provide accommodations for a person with disabilities. Once they make the determination that there is a violation that occurs, they themselves, the EEOC, can bring a claim, or they can give you what's called a right to sue letter. Once they give you that right to sue letter, you as the defendant, or I should say the petitioner, would have an opportunity to bring a claim. You could bring that claim within 90 days. Going back to if the EEOC decides to bring the claim on their own, which they've decided to do in this case, they can now say, look, we're going to bring the claim on behalf of petitioner. They don't do that as often. Why? Because they just don't have the manpower to go all around the country and sue on behalf of employees. However, once they bring it, you can recognize that the claim is going to be strong. And they don't get here lightly. They get here because failure of negotiation. Hey, we attempted to take you through the process to let you know what you guys have failed to do, which is the clear writing of what ADA requires, and you aren't just responding. So now we sue you.
So part of the ADA, the Americans with Disabilities Act, it mandates those workplace accommodations unless it causes undue hardship for the employer. What does that undue hardship look like, and how do you go about proving that? Well,
you're going to have to say that, first of all, that there's a cost connected to this. That's a hardship, but it has to be, the case law is not good on behalf of the employer to be able to support that there was some type of undue hardship. Additionally, it's going to have to cause some disturbance or modification significantly in the way that you do business. And creating an accommodation for these 4 individuals, it would be hard pressed to say that FedEx, now a multi-billion-dollar company, can't make an accommodation for these 4 employees without it making some significant or damaging to their business. And those are the 2 standards that the court will look like. How hard would the accommodation be, and how much cost would it take to do, and what kind of disruption would it cause to your business? I think all of those would be minimum to ensure that these individuals would meet the accommodations necessary to do their job.
When you are as large of a company as FedEx, even if it's just one regional area like Kernersville where this is, and you've got deep pockets, does it make it harder to defend yourself and go, it's difficult for us to make these accommodations even though it's just 4 people? Like, how do you defend that?
Yeah, when you're Goliath, it's hard to say, hey, I don't have the massive resources to do it, but it still could be a valid concern. I mean, if it would cause a major disruption to the way business is done, if they're doing a job that was something that required, a massive modification to a process or to a system, some multi-million-dollar adjustment to the process, yeah, I could see them making that argument even if they are the Goliath. But I think in this scenario, it's going to be hard for them to be able to prove something like that. What I think most likely happens is, hey, we dropped the ball in terms of settling. We didn't take this serious when they brought it to us, they as a petitioners. We didn't really take it serious when EEOC has got involved. Now we'll take it serious and we'll attempt to go back to the table. There's always an opportunity to settle. You may settle all the way up until a date of trial. You may settle even after you pick an impanel a jury. But at some point, settlement is most likely here because the cost of litigation is going to be extremely, against the recommendation of any legal team.
And as you've brought up before, not settling means a trial, it means discovery, and who knows what they can have access to. With an EEOC investigation, they got involved here because the employees, maybe triggered that. But what if an employee never reports these things? Does the EEOC routinely check all of these things, or do employees, is the burden on them to actually speak up about it?
The burden is going to be on the employee. Back to the manpower. They don't have the people, the bodies to go out there and be at every location all at once. And so it has to be initiated by the individual. Now, even we go back a step further. The employee, if they haven't exhausted their administrative remedies, the EEOC will say in the course of the investigation, hey, we believe something occurred, but you didn't even go inform or notify the employer that this was happening. And so a lot of them die right there, where you guys didn't take the administrative remedies to make sure that you can even make it ripe for us to take over. This claim checks all the boxes. I had a couple that have been like that. Most of the clients that come to me, they're coming to me because the EEOC gave them the letter, the right to sue. We're not going to take it for you. Best of luck. Go find an attorney and you can go sue on your own. That's not a bad thing. It's just they don't have the resources.
Got it. All right. Our chief legal analyst, Kali Frodes, weighing in. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.